Welcome to today's GNCC Espresso webinar, all about the Ontario government's Working for Workers Act. Inspired by a 2016 law giving workers in France the right to turn off electronic work devices outside of business hours, in 2018, the federal government started reviewing labor standards and mulling whether to give workers the right to ignore work-related messages when at home. Ontario's government opted not to wait for federal regulations, which have not yet been tabled, but to draft their own. As of June 2nd, employers in Ontario with 25 or more employees must have a written policy with respect to disconnecting outside of business hours. The new law was part of the Ontario Progressive Conservatives Working for Workers Act, which was passed in late 2021, and it is the first law of its kind in Canada. In part, this law was created by the increasingly blurred line of individuals working from home and out of the office and workplaces, mainly due to the pandemic. Employers are supposed to detail how employees can disengage from work-related communication, including emails, audio, video calls, and sending and receiving messages when they're meant to be off the clock. The new rules must apply to all employees, including managers and executives. And there are other aspects to the Working for Workers Act, ones that might not get as many headlines, such as obtaining non-competition agreement and more, but equally important to employers and employees. As such, we have many questions that have come forward from you, our audience, and we thank you for actually being with us and wanted to let you know that we are taping this recording also for those individuals who have actually submitted questions to us, but who might not be able to join us actually here right now. And it is my great honor to actually introduce to you two experts when it comes to all the questions around this act. We are being joined by Vita Gauley, who is the partner at LCW Lancaster, Chown and Welch LLP, who focuses her practice in employment and labor law. She received her undergraduate degree in political science from Brock University and obtained her Juris Doctor from Western Michigan University and was called to the Ontario Bar in 2012. And Erin Stevens, founder and principal consultant of Oxford HR Group, which focuses in the areas of HR and occupational health and safety, compliance mapping, fostering safe and thriving cultures, compensation design, including pay equity, and aligning people's strategies to organizational purpose. Erin can also be found teaching at Conestoga College in both the Human Resource Management and Occupational Health and Wellness program. Vita and Erin, thank you so very much for being with us. And the same goes to all of our participants. My name is Mishka Balsam, and I will be your moderator for the next hour. And I thought as we're moving forward, let me just give you a little bit of overview of the format that we have. As I had just mentioned, many of you have already provided us with some questions around this act, but we also want today's webinar to be really an interactive format. And so as many of you already know Zoom, there's two options that you can utilize. If you want to ask a live question, please use the hand symbol at the bottom of your screen. You can look for it and we know that you want to and have a question and we'll unmute you. And the second option is utilizing the chat function, which I think most of you are familiar with. You can type in your question right there and we can see it, and we're committed to getting to it. And if you wish to enable live transcript, please refer to the bottom of your Zoom screen again for that particular option. And lastly, I wanted to mention, if you are experiencing any difficulties in any way, shape, or form, just send us a quick chat. And my colleagues, Savannah and Brad, behind the scenes are trying to help you out and address them as well. I'm wondering if everyone is all right. Maybe we can jump into some of the questions, because the early questions actually speak to the act itself and maybe some of the things that people are wondering about. And Vita, maybe if I can start out with you. The Working for Workers Act 2021 is already in effect. Can you tell us when the 2022 Act takes effect? And is there any sort of grace period for either?
Wonderful. Thanks so much, Mishka. That's a great question. And thank you again for having me, and a pleasure to be here with Erin to talk about this, because it is a hot topic. And we are fielding a lot of questions surrounding a lot of the elements to the Working for Workers Act and what is coming into play. So the Working for Workers Act 2022 is live. It is in effect, and it's received royal assent, and that was effective in April of 2022. So what is sort of up in the air are some of the pieces of the act. So as you also mentioned, one component being the need to have certain policies in place with respect to disconnecting that had a June timeline and is required to be in place for certain employers. So within the act itself, there are some timelines that are still ongoing and some flexibility, and some components that don't even have dates yet. So the act itself is law, but we are still working with timelines within the act.
Thank you so very much. On what sort of, when you look at it, what sort of investigation or enforcement do you expect the government to conduct, and what penalties can employers expect for non-compliance? I know it's early on in some of the areas, as you had mentioned, they're not in effect yet, others are yet. And what can employers expect on that end of it?
So I think that, to your point, we're unsure of exactly how this is going to roll out, but we are informed by certainly prior amendments and what we've seen in terms of enforcement moving forward. So we can kind of gauge what we can see. And I think that, the Working for Workers Act is largely amendments to the Employment Standards Act and the Occupational Health and Safety Act, which we know is governed by the Ministry of Labor. And the Ministry of Labor is charged with enforcement and follow-up and all of these elements. So I think what we can expect to see is a lot of whether it be spot checks in terms of, employment standards officers stopping by, checking in, seeing, what policies do you have in place? Have you done this, and the checklist to do so, as well as, complaint-driven follow-up. So the second most common type of enforcement comes from complaints, individuals calling in, suggesting that there might be concern internally with their employer or with a workplace. And then, of course, then you'll get the spot check from an employment standard officer or a representative from the Ministry of Labor to go through that process. I will say that, generally when we're dealing with new legislation, new requirements, we're not going to see, and it's not expected that it's going to be sort of, full fire right out of the gate and enlisting fines and those kind of heavier penalties, but rather, those compliance orders to say, listen, you need to get these things in check, and you need to follow up, perhaps get your policies in order, get your sign-offs, those types of elements, and then there'll be a follow-up date for compliance. So I don't expect that we're going to see employers getting a number of fines right off the bat, but those compliance orders might start coming in, and gives the employers the chance to, of course, get their house in order, ensure they have what they need to be compliant. So those are a couple of things. I know one of the hot taglines in terms of some of the penalties were under the Occupational Health and Safety Act. We did see the maximum fines allowable for certain infractions increased. So whereas previously maximum penalties for individuals were 100,000, they've now been increased to 500,000. And one of the newer ones or the bigger changes under that component is with respect to the addition of the ability for now the Ministry of Labor to impose fines to directors and officers of corporations in matters of extreme injury and worker death. So it's really signaling that those controlling minds of the organization really need to take health and safety seriously and ensure there's a safe workplace. And again, this is in response to some workplace deaths we've seen in Ontario over the last couple of years, unfortunately. So now there is the maximum fine that can be imposed for those actions of 1.5 million, as well as a prison term, so up to 12 months in prison. So it's really signaling that, when it comes to safe workplaces, particularly in high risk settings where concern of severe injury or death could take place if it's not complied with, that the labor board, the government is going to take this very seriously and can go as high as those penalties. So that was another change we saw.
Vita, I really appreciate actually you outlining that, because I think it really also reminds all of us who are actually sitting on boards, sitting on advisory councils for different organizations, to ensure that those organizations are following actually all the standards and laws that are meant to be in place, and that is our duty to do so. So thank you so very much for bringing this up as well. And this, Erin, I'm going to move some of the questions over to your area that have come forward. And this particular one, I thought you would be able to help us out with. The legislation requires a disconnection from work policy, but doesn't specify specifically what should be in it. Can you speak to what a good disconnection policy would include, and if there are maybe even templates available to those participants who are with us here today, where it might be easier for them to put it in place?
Yeah, thank you. And thanks for having me. It's really a pleasure to be here with you guys and partner up with Vita here for this. So in response to that question, you're right, the ESA doesn't really specify what should go into the policy. So it really leaves it open for employers to decide. So I think that it's going to be really critical for employers and businesses to think through what we actually want in those policies. The legislation doesn't really actually give the right to disconnect, just says you have to have a policy in place per se. So it's simply asking us to document how we're going to behave in the workplace when it comes to the after hours piece. So my opinion is to think about what you're prepared to comply with, because once it's in a policy, you have to adhere to it and enforce it within the workforce. I suggest maybe speaking with specific departments in your organization to get a real good sense of what their needs are. That will help you inform the practical piece of that policy. Okay, so we need to consider different schedules. Do you have different offices in different provinces that maybe are you going to extend this policy across all provinces? Do you have on call? What does that look like? Do you have different groups of employees that may be impacted differently with the after hours, such as emergencies, on calls? Like, who are those individuals that you are going to expect to answer emails and phone calls after hours? Are we going to have things that are like out of office replies, or maybe a tagline at the bottom of your email to say, this may be my hours, my working hours, but don't feel like obligated that you have to reply, something like that. So all those things need to be considered, and it's also linked to like hours of work rules that are already in ESA that we wouldn't want to compromise as well. As for templates, sorry, I'm sure there's lots of places you can get templates. I'm an HR consultant, so I have a few templates that I can share after the event as well.
Thank you very much. Yeah, there have been a few inquiries about the templates, just because it's newer, and it's a legislation right now that in aspects of it are only mandated in Ontario right now as being the first province to move forward in it. So I think this would be really helpful. Erin, I wanted to follow up on it, and there are quite a few more specific questions that a couple of companies and employees and employers have brought forward, and I will get to them in a second. But there's one aspect that I thought I would love your expertise on. Businesses with 25 or more employees now need to have a written policy on electronic monitoring of employees as well. So this is slightly different than what we just talked about. Can you speak to what a good policy would look like when it comes to the electronic monitoring of employees?
I could try. So it is interesting. The bill doesn't define the electronic monitoring piece yet, so it makes it difficult again for employers to really know what that constitutes as monitoring. However, it does say we still have to have a policy, and it at least has to contain a description of how you're going to monitor and in what circumstances that you might do that. In a policy, we may want to include, like, are we monitoring emails, or are we monitoring the internet usage, or are we tracking vehicles depending on the type of business that we have? So you'd want to include that and disclose it in the policy. You know, I'm not an IT professional at all, but there are probably things that are behind the scenes in a networking side of things that we might want to review and see if it captures any data that might need to be disclosed as well. And then the other part of that is the piece of information that what we gather is how we're going to actually use that information when we do monitor that. I don't know, Vita, maybe you have anything else that you want to add to that?
Yep, absolutely. And I think you sort of hit it on the head. When this has come up, at least in my practice, I start from the basics. Well, what are you doing now? So as an employer, are you monitoring regularly? Is it incident sparked? So is it, well, okay, we have an incident in the workplace, so now we go and check. And once you understand sort of how you're using it, then it's going to assist you in framing your policy, because that way you can start incorporating and disclosing, well, this is how we are electronic monitoring. This is what we do, and this is how we might use it. And again, if it is incident based and it might be relied on in performance management or disciplinary, be transparent and confirm that, because that's part of the policy obligations as well, so that employees know the rules of the game, so to speak, so they can play within it. So they understand that, you know, if I'm web surfing or shopping at lunch, I need to know if that's okay or not, or if that's going to be something that's going to form the basis for disciplinary later. And again, it is, you know, we work within templates, but it's very important for employers to really think about, well, what do I do? What is my use? Because a template doesn't always fit every workplace, and you don't want to just put it out there just for the sake of having it, because as Erin mentioned, that's going to be the standard that you're going to be held to and questioned on down the line if there's ever concern. So those are the types of items that you would have in there. I will say that, you know, most workplaces don't have active surveillance going on their employees. And it is a matter of just saying, you know, well, you are on our server. You do access and utilize our email. You do utilize our internal chats or GPS or trucks. So it is just to say we have the ability to monitor. This is what we use. Engage your IT professionals to ask them, to say, okay, well, what is it that we're doing? How is it that we access? What type of information do we store or not store? You know, do we have rollover every month? So that type of information, you know, get it from your IT professional so that you can inform yourself as to what is actually happening in order to include it. And I think that there's, you know, what I would call sort of these domino things that come up as well that we have to be mindful of, because when we are monitoring or storing information that we're monitoring, you might trigger certain privacy legislation that you might not even know about. So is there, you know, personal health information going back and forth that you're now storing? Do I use my email to email back and forth with my physician or my health specialist? And now that's being stored somewhere. So these are all the things that you think about. And again, good, bad, or ugly, as long as you're disclosing and it's in the policy and you're confirming that, yes, we do have access to these things. However, we are not storing, we're not utilizing, or not, you know, so concerned with if you're storing personal pictures on our server, but more if you're, you know, disclosing proprietary information to someone else from our computers or software systems. So I think that those are the elements that you think of, and then as long as you're transparent and include them. Again, we are in an area where we're not quite sure of what all needs to go into these policies, because we are waiting on regulations to kind of direct us a little bit more because it is so new. So this will be something that will evolve as well over the coming months, I anticipate.
Yeah, thank you so very much, and both of you for answering and taking this particular question. Vita, there is a follow-up question in light of what you had just mentioned, and it's related again to the monitoring of it. If an employer monitors one individual, but maybe not all individuals, because there's maybe due to performance concerns or other things that are there, do they have the right to do so, or are they needing to show that this is that they're enacting this policy across the whole board of all of their staff that is there?
So, and you know what, that's a great question. And it does come up a lot, even pre this legislation. And, you know, when I have a client engage me to say, you know, this is what we found, and it's usually after the fact to say, well, we've been monitoring and this is what we found. Now, what can we do? I'm going to take a step back and say, okay, well, what policies do you have in place? Even pre this legislation, it really has, in terms of our common law and courts and man-made law that have directed this on, it really has indicated and firmly planted that employees do have a certain level of an expectation of privacy, in even when they're using employer computers, employer emails, employer servers, etc. And the way to ensure that that expectation is clear, if you're going to change it, is by having it outlined in a policy to say, you have access to our emails. It has to be expected that we can access if needed, that it is to be professional, it's not to be used personally, or if there is a personal element allowable, then you include that. So that's sort of the starting point to say, okay, well, what do you have in place? If there's nothing in place and there's been these concerns that have arisen that have triggered certain items, then the next step is always going to be, you're going to have to meet with your employee and you're going to have to be sort of candid and transparent and allow them the opportunity to explain what's been going on. So if, for example, there is, you know, a significant amount of, you know, online shopping or surfing going on when it should be work going on, is to sit down and say, listen, you know, we have concerns, we have performance-based concerns. This is our understanding. We need to hear from you what is going on. Allow them the opportunity to respond. You know, in being transparent and confirming that, you can say, listen, there have been touch points or monitoring that has been incident-based, to make sure that they understand going forward. I will say that if it is going to be an incident where an employer is going to want to move and terminate or action a severing of the employment relationship based on that information that they've obtained without probably providing the employee with sufficient notice of that monitoring, you know, we will be talking about sort of the implications of that and how that might come out in terms of what can be relied upon. Because again, a court is going to scrutinize that type of monitoring absent an employer policy that very clearly indicates that we have the ability to do this, which then of course sets the stage for that expectation of privacy in what they're doing.
It's excellent. Thank you so very much for clarifying that. And I think this is really helpful to the participant who brought it forward too. Erin, this particular policy is looking at businesses and organizations with 25 or more employees. That this having to disconnect from work policy, I'm coming back to that. Do you think it's advisable for smaller businesses to do so as well?
Yes, I do. I think it's about, really, I think in my opinion, it makes good sense from a cultural perspective as well. However, that being said, remember that whatever you do put into a policy and roll out, you have to adhere to, and the leaders of the organization should really make an example and follow that as well. I do think it's good practice from a employee retention perspective. We're seeing now in this sort of great resignation that employees want more of that sort of work-life balance, and this policy sort of demonstrates that for them. As an employer, you're doing what's right for the employees. So in my opinion, yes. I don't know, Vita, if you have anything else to add to that.
I would agree. And I know that there is the question sometimes of, you know, we go up and down or we fluctuate depending on time of year. Yeah. If you're even close to it, I wholeheartedly agree with Erin. I think it's a good opportunity to really just clarify what the expectations are too. You know, as Erin mentioned, this doesn't create a right to disconnect, so to speak, but what it says to employers is, you know, be transparent about what your expectations are, what is and is not required in terms of off-hours communications? Is there differing positions that require different levels? And then at least employees know what their expectations are, because I think oftentimes it's just that blurred expectation or obligation that an individual has. And I think that, certain individuals feel that they are, required to be super responsive off hours. And that's not necessarily the case. If you're like me and perhaps you're working later at night and you send an email, I don't expect a response back, but I send it. So some of the tools that have been indicated are important to have, but no matter the size of the organization, those underlying concerns and the need to clarify what is and is not necessary is always good business practice.
I fully agree. And I also think from an employee perspective, I think we have to look at that employers are attracting employees from different size companies with different experiences. So it would be very difficult for an employee who has worked for a different company, of a bigger size company, and is now moving to a smaller organization, to likely not have some of that framework in place and that understanding as they're actually trying to integrate into the new work culture. So I think all around, I think it's critical, and most definitely we support that. Here's a question that's likely for both of you. Can you speak on to how changes for gig workers using an electronic platform might affect employers? For example, does a restaurant that uses a service like DoorDash, Skip the Dishes, or Uber Eats need to be aware of anything, or are the changes aimed exclusively at the digital platform operators?
That's great. So Erin, I can kind of jump in.
I'm going to let you take that one, because I don't have any clients in the restaurant industry, so I haven't dove into that yet. But
So, and this is something that, has of course become very prominent in the last few years, and absolutely the pandemic has kind of heightened that, because we've seen this explosion of this type of workforce and this type of work come into play. So we do know that our current government has taken an interest in this. We do have this Digital Platform Workers' Rights Act, I believe is the title of the working act. It is not enforced yet, and we don't have a date yet for the implementation of these items, but we know that it is out there, and that this is an area that isn't going away anytime soon, so it likely needs some direction on. What we've heard is that under these new rights for workers, so I'm going to start from the worker side of things, is that really what they're looking to do is protect workers in the sense of, being entitled to certain information, what their total remuneration is, how it's broken down, how are user fees or service fees going to play into that, to really get in line with being able to have expectations around payroll dates, regular payroll, regular pay dates, to create that more standardized or reliable form of income versus the sort of gig mentality. One of the big items too that have come out are that there is now these rights and protections that would otherwise be found under the Employment Standards Act, that include the ability to deal with disputes or issues in Ontario. We've heard of these arbitration clauses that are buried deep in the user regulations or T's and C's that say, okay, you can enter and you can work for us, or you can be a driver for us. However, click yes, and if there's any disputes, we have to go to some foreign country and you have to pay a certain fee, and we will arbitrate there, which is just not feasible for individuals that might be being taken advantage of. So those are the types of things we're seeing that are likely to be encompassed and included once this takes effect. From the employer or organizational side of things that might engage or interact with these employees or these workers that are in this industry, is the main one that has come up, and it seems like a small thing, but it really isn't, is that the obligation to open your restrooms or your washrooms and allow individuals to come in and out and be able to use those. So that's the one that is really the main interaction with with the individuals. So it just requires that, if they're coming in and out, that they be able to use facilities. And I think it really goes to the heart of the nature of the work they're performing, is that it is, nomadic and mobile. So as a part of the, the infrastructure that is driving these individuals and this type of work, you have to be part of allowing, certain amenities to them in order to be able to facilitate that work.
Vita, that's actually an interesting point that you're bringing up, because we received one particular question on exactly that topic of where the new legislation requires business to open up washrooms to workers delivering or picking up from a business. This is now a number of exceptions, including some health and safety reasons were the exceptions that are indicated. And one of the participants today had asked, would COVID transmission constitute an acceptable health and safety reason? And this is a really interesting question, because we have many businesses had to deal with that over the past, I don't know, 2 years anyways, but I was wondering if you had any thoughts on that.
And that's an interesting question. And I think we are in timing wise with respect to the pandemic. We are, we're seeing sort of a shift. We're seeing the, removal of a lot of these public health directives surrounding COVID-19 and the pandemic, and what organizations are required to do. My comment to that would be to sort of take a step back and say, okay, well, what COVID type policies or directives is the organization, the restaurant, the bakery, et cetera, what do you currently have in place? What are you requiring your staff to do? What are you requiring your patrons to do? Individuals that are coming in and out. And I would say that, in those circumstances, you wouldn't be well founded to impose any increased measures on those individuals than perhaps you're doing for your patrons and your employees. And I would say that that's sort of where your starting point would be. Certainly if there is, passive screening question concerns, somebody is very visibly ill or concerned, from a symptomatic standpoint where it is, apparent from a visual perspective, then maybe that's warrants, maybe can you put on a mask? We're going to ask you to wear a mask, similar to what you might do in, the terms of any other individual attending as well. But I will say likely to full on say no pickup drivers or DoorDash, Uber, et cetera, can come in because of COVID. I think you will get pushback, and you might not be on solid ground to just completely one-off prevent people from doing so on that basis without more.
That makes full sense, actually. Erin, back to you. If an employer doesn't have a need to contact an employee after hours in case of an emergency, for instance, what are the options? What do you think needs to be reflected in the HR policy that speaks to exactly that particular way of allowing an employer to connect with an employee?
I think I touched on this earlier, but I do think it's where you be very explicit on the different groups of employees within the policy and what those expectations are. We all have individuals in our organizations that have authority to respond to, if there's a fire in the building in the after hours and those sorts of things. We have to designate someone to handle those in those emergencies, especially if you are a 24-hour operation. Make sure we include that in our policies, and it might be a good idea to add that into job descriptions and maybe even employment contracts if you include job descriptions in that.
Yeah, that sounds fair. Vita, do employees have to be on call, and what would it have to look like legally for them, for us to expect them to be on call?
Yes. So in a very lawyer-like way, I will say it depends. I go back to and a point that Erin's brought up and that I touched on, the sort of right to disconnect legislation is very clear that it doesn't create new rights. So if these sort of off hours or timing or expectations around responsiveness, existed before they will continue to exist. So it is really that that idea that employers be transparent and say that this is the expectation. So yes, if employees were expected to work on call or be on call for certain periods of time, in which it is part of their existing employment expectations, whether it's a written agreement or an oral agreement, that will continue. This doesn't take away that obligation and that ability for employers to reach out. So in terms of when we take the step back and go to policy, oftentimes, your policy language, you want to make sure you're being transparent, you're clearly outlining expectations, but you're also being a little bit, flexible, because a lot of times workplaces are flexible places. And we say things like, in the certain exceptions to these exist. On-call employees who were previously expected to, be, take certain shifts or be on call. And so long as you're getting back to adhering to those hours of work obligations, minimum wage obligations, all those other things that already existed and were already in place surrounding these employees, then you're going to be onside this new obligation as well, because that's the whole idea. It will still exist.
Very good. Erin, you work with many employers on shaping policies and working with them. Are you recommending that employers should engage with their employees? Because I'm listening to this conversation and wondering if there might be a difference in understanding from an employer's and employee's perspective here. And do you suggest that employers work with their employees in shaping this policy to be sure that they have a consistent alignment in understanding?
100%. I think that you get more buy-in into a policy when individuals have a voice in saying what their expectation is. So yes, I do advise that. It also goes along to my previous statement that it's part of the culture that you're trying to build. If that is the culture that you want to build to retain your employees, they want to have a say in the things that impact them in the workplace. So that's my opinion, yes.
And I think it's very sound advice. I think it's very, very helpful actually for organizations that have that, or at least have a core group of people that will give them feedback too on what they're moving forward. One of our panelists is asking a question, and I think, Vita, I'm going to direct it your way. It's indicating agricultural employees fall into different rules and standards, such as farm employees. Are they included in the disconnecting from work policy?
So short answer, yes, they haven't been excluded from that obligation. And again, it is just a matter of really outlining for individuals that, whether they're farm workers, whether they have set hours, or, if there are circumstances, particularly in agriculture, if weather shifts and they might need to be on call, or there are those emergency situations, that's outlined to say that, this is our expectation. However, there are circumstances, emergencies, where you will be contacted and the expectation is X, Y, and Z that is consistent with what is already happening.
Thank you very much. And here's another question, and Amita, I think I'm going to direct it your way, but can an employee be asked to work or to answer calls, emails, and so on outside of regular work hours if they're paid for that particular time? And do they have the right to refuse even if pay is being offered?
So it's an interesting question. I think that context will always be key in dictating that. I will say that the legislative amendments with disconnect wouldn't change whatever the employee's current employment agreement and expectations were. So, there's certainly, if an individual is, an hourly employee with set hours, and then there is a call in, on an off hour time to say, we need you to come in for a certain amount of hours, and you will be paid for those. There already are, rights and obligations surrounding their ability to decline and say, well, no, unfortunately, I can't. This wasn't pre-scheduled. There wasn't, enough notice to allow me to come in. Those will all still exist. If there is an individual who is, a management level employee, and there's expectations that, they are salaried and their employment contract contemplates certain off-hour needs and expectations, then those would also still exist. Certainly anybody who is working is entitled to be paid for that work. There's no way to get out of that. And I don't think that that's what this question is going to. But really, in this sense, it truly does depend, because it's going to go back to what is that employment relationship with that individual? What are the expectations? What are the obligations? And what are the terms that surround what is expected of them off hours?
Yeah, thank you very much. Erin, you work with a lot of organizations in drafting policies that are there. On this particular one, is there anything that people need to, or you would say organizations need to be aware of that you have come across where you're saying, here seems to be a gap, here is something that organizations need to bridge to strengthen their policy or to put the right policy forward?
I'm not sure I understand the question.
I think it's like, have you worked already with organizations who have drafted a policy around it? And are there any, when you're working with those organizations, are they coming across, are you noticing here's something that seems to be an obstacle, a barrier that people are coming forward with, or a hindrance that might not create the most effective policy in moving forward?
I haven't seen any real barriers yet. The main thing that I'm seeing is people don't understand what to put in the policy. So the barrier is thinking through all the different aspects and the roles that they have and trying to fit that into a policy. I've seen a few employers that are thinking that it should be the same for everyone when it doesn't have to be, and then trying to fit that into sort of one statement or one type of policy. So my sort of advice there would be to make sure you take a really practical look at all the areas of your organization, the departments, the needs, and draft your policy with respect to that and the individuals that have responsibilities at different levels of the organization. I don't know, Vita, if you have anything to add to that too.
Yep, no, I think it really goes down to it. I think particularly, and I know we've kind of touched on it a number of times with the right to disconnect. I will say the biggest thing is the misconception around what is actually required, because it has been titled this right to disconnect, and so employers are very concerned about, okay, well, but how do we do this? How do we make sure it's clear? And we have to take a step back to say, well, no, the legislation doesn't really say that. The right is to have a policy with respect to disconnecting and what those expectations are. So I will say that's the most common thing. And again, that it is really saying that rather than try to fit your workplace into a template, what is your workplace doing? And let's create that so that you're just really outlining what is happening and what those expectations are.
Yeah, thank you both actually for answering it, because I think this is one of the questions that quite regularly comes forward from individuals, because they're sitting there and saying, like, how do we best move forward from it? And both answers are extremely helpful here. We have one specific one, and this is coming from the tourism sector, and they're asking is, they employ 50 people in the summer, but only 5 over the winter time. And does it have to, therefore, do they need to also have a disconnect from work policy? So and I think it speaks to the same, if any business has 20 regular employees, for example, but takes on 6 temporary workers to help fill a larger order for another, like, do they need to have a policy? So I think this is really talking about the businesses that are right on the cusp. Sometimes I fit into this model, sometimes I don't. Some of it is permanent, some of it is temporary occasionally. Do I need to have a policy? And I think we've established during this conversation that it's very valuable to have a policy in place, if you're bigger or smaller. But I think they may be specifically asking and saying, do I need to? And I think it's a slightly different question, although we do know it's best practice to have it. I think it's still valid to saying, do I need to?
Yeah, my interpretation of the legislation is that whatever number of employees, all employees on January 1 will dictate whether you actually need the policy or not, outside of us advising that it's valuable to have regardless. There isn't anything else that states otherwise. So it's that January 1st date. But Vita, you can correct me if I have misinterpreted that.
No, and that's the legislation and how it's framed as well. I offer caution to those that rely on it strictly because, again, depending on how your workforce is managed administratively, you might have individuals that are on layoff or that are on leave, because of that seasonal sort of element. So, while you might only have 5 bodies working on January 1, when you pull your list of employees that include inactive, that might be something that still triggers that obligation. So again, we don't know how employment standards officers, when they do their spot check, what information they're going to rely on necessarily, because even if an individual is laid off, they're still technically an employee of that organization, even if it's a seasonal layoff. So I would agree with Erin and offer caution to employers who opt to interpret it strictly.
Thank you very much. I think it does clarify it for those people who are participating who has put this question forward. I'm wanting to move for a moment away from the right to disconnect and the conversation we've had so far and look at December 2021, when the province's Working for Workers Act came into force, prohibiting employers from obtaining a non-competition agreement from an employee subject to certain exceptions to this one. And the questions regarding this one that has come forward is, one of them is, are non-compete agreements that existed before the legislation was passed still valid? And should businesses start deleting those clauses from existing contracts? And Vita, maybe if I turn to you first, and then Erin, because of your experience that you have to maybe as a follow-up to it.
Sure. No, and that's a great question. And I would answer it in the sense that non-competitions that existed pre this legislation, and I believe the date was October 2021, where they put that line in the sand, they will not be unenforceable for reasons of the legislation. They might be unenforceable for a lot of other reasons, but not because of the legislation. So we have actually had the court interpret this provision early into 2022, and they did confirm that the change in the legislation doesn't affect pre-existing non-compete clauses. However, for those that practice in this area and in the employment law world, this legislation is catching up with what courts have really been instilling in the employment law world, and that is non-compete provisions are going to start from a point of being really looked at as unenforceable. And then the organization or the individual trying to enforce it is going to have to show that they did everything they could to both limit the language and scope of the provision itself to protect those specific business interests, and show why it should be enforceable against that individual themselves. So really looking at those executive level, high level key personnel, and why and the scope of those provisions. So my long answer to short is that yes, they will still be enforceable, but they might be unenforceable for other reasons. So those for employers that have them in place, I would say that it's always apt to take a look at them to make sure they're being used appropriately, to make sure that the language is appropriate in them if they predate that October date. And again, and if it's something that they just, you want to be sure of and not cause any concern down the line, you can provide notices or updates to employees that do have them in written employment contracts, just confirming, something along the lines of, further to your employment agreement dated X, we confirm that the company has no intention of, relying on or enforcing this post-employment relationship and filing it away. Because at the end of the day, if you're not really going to rely on them and you recognize that maybe they might be a little bit too broad in scope, it's better to be transparent so that way an employee is not concerned post-employment relationship that, they can't try to find new work or in a certain industry.
That's excellent. Very good point. Erin, to that point, do you come across people that are actually adjusting and are you suggesting people to adjust their employment contracts with their staff to reflect exactly what Vita has said? Employers actively looking for that?
Yeah, some employers are asking that question, and I agree with Vita on the case law and stuff that has taken place prior. The reasons that it might be sort of not relied or not enforced on afterwards might not be related to the new legislation. I always caution that just arbitrarily making changes to employment agreements without really good reasons, to always seek legal advice. Anytime, actually, we make a change, to seek legal advice. But if there becomes an opportunity to make a change, that would be the time, because you're already making other changes to someone's role or compensation, to look at those employment agreements and make sure that they're up to, what the requirements are now.
Mhm. So it's actually an interesting point you're bringing up. And so do you think that in light of these more recent changes to the Working for Workers Act, is it a good time for employers to not only update their policies, but also look at their existing employment contracts? Is the timing right to update all of it?
I think HR professionals need to constantly be on top of that and looking at that, and making those changes when they can. So anytime. So yes, the answer to your question is yes. This is always, especially over these last 2 years, we've seen so many changes to workplace legislation and employment agreements in general. But again, it's always important to take the opportunity when you can, and you have other reasons for making those changes, to make sure that your policies, your employment agreements are up to standard.
Thank you. Vita, this is a question to you. We're coming back to the non-compete clauses that are there. If businesses are concerned about former employees or existing working for their competition, bringing sensitive insider information or scientific or technical knowledge to the competition, or going into business for themselves as a competitor, are there any options that employers have when it comes to that?
So yes, and I think that these, they're not necessarily new options, but they're ones that really are going to take a big focus in light of really clearly the legislation saying, we're not going to really deal with non-competes except for these very specific circumstances. So when I'm always working with a client over, okay, well, what's included? This is a new employee, or we have employment contracts in place for certain roles, that we look to, okay, well, where's the risk here? So what's the type of information you're looking to protect? What is this individual going to have access to in the normal course of business that is really proprietary and important to the organization? So the main provisions that I find are the ones we really focus on are your non-solicitation provisions, because those are not precluded under the legislation. So those are still enforceable, and they're a great tool for employers, because what you're saying is that you had access to certain information from us. In the event you depart, then you can't take those active steps to solicit away, whether it's clients, contracts, employees of the organization, that would be to the organization's detriment and potentially to the individual's benefit, or whatever new organization they go to. So those types of provisions are still going to be key for that, because it's going to protect that active step that an individual might take. So they can still go work for a competitor, but they can't pick up the phone and start calling your client list without then, of course, risking certain damages or court action that would flow from it. The second one is that you really focus on your confidential proprietary information provision as well, highlighting what is going to be deemed confidential and proprietary information in which an employee has an obligation to maintain on a go-forward basis post-employment. So it's not going to be anything and everything from the employment relationship, but you are going to be able to say, client information, client database, HR plans that are very specific to us, marketing plans that might be specific, workplace dependent. So those types of provisions are going to be the ones that, employers are going to want to take bigger note of, because that's going to form the basis of how they're going to be able to protect those interests, post-employment relationship. And they're going to be ones that courts will say, when they're drafted properly and when they're in place and the individuals are both aware of those obligations, are going to be enforceable on a go-forward basis.
That makes sense. An exception to the Act states that executives can still legally enter into a non-compete agreement. Can you speak to that, or what would define someone as an executive, and what a good non-compete clause might look like for them?
Absolutely. So I always say it's, going to be your C-suites. So your chief executive, your chief financial, your, chief human resource professional. So it really is truly going to be limited to those executives, president, that type of level employee. And the idea is that at that level, it is almost inferred that you're that key personnel. So that if you leave and if you leave without adequate notice, that the organization will need a period of time in which to get its house in order, so to speak, to protect itself and allow that adjustment and to bring someone else to protect their business interests. And that's going to be that period of time in which a non-compete is going to be appropriate. Mm-hmm. So I would say, if you're going to want to impose a 2-year North American wide, any type of business non-compete, it's not going to be enforceable. What you're going to want to look to is what is the minimum amount of time an organization is going to need to ensure it's protecting itself. What is the scope of the work that is performed and that is particular to the organization? And what is the realistic geographical scope, right? It's recognized, listen, some organizations are international, multinational, all of that, some aren't. Right. So if you are a Niagara-based industry with no clientele outside of the region, it's unlikely you're going to get a province-wide non-compete to be enforceable. So you're going to want to make sure it's tailored properly, that gives you that period of time. And then a court that's the scrutiny a court will put on it. Did you make sure it was the least restrictive to protect your means? And that's the way it will be reviewed. The second exception, which is worth noting as well to that, is if it's part of a sale of a business or a business transaction. So, for example, if there is, I'm a business owner and I sell, whether by asset or share purchase, et cetera, sell interest in my business. And then I stay on as an employee. I might only be a general manager, or I might be, something that's lower than C-suite. But because of my, intrinsic knowledge of the organization and the business, that a non-compete in my employment agreement, if I remain with a purchaser, will be valid and enforceable under the Act because of that.
Excellent. Thank you so very much. I think it really does answer the question. I'm conscious of the time. And so, Vita, if I could ask you for one question, has come in from a couple of individuals, if I can ask you to take a minute or two. And I think it's one that is connected to the opioid crisis that we're experiencing across Canada and specifically here in Niagara as well. Businesses now have to provide kits if there is a risk for an employee having an opioid overdose at work. Can you tell us how a business might assess this risk, and is a medical opinion of some kind necessary or advisable, or is it down to the employer's own judgment?
So as of right now, we don't have a lot of details on that. We don't have a date for this in particular to be implemented. So it's one of those that has been caught by the legislation, but we don't have the regulations attached to it. We don't have an enforcement date on it. So it's almost a to be determined. What I believe and what we can anticipate is that the government is looking to protect those high risk type of workplaces. So it's that, if there is reasonable knowledge to support that there could be risk of this being needed in the workplace. A lot of the examples or a lot of the discussion is around construction sites, having this on site, having somebody that's prepared to be able to administer in the case of emergencies, because it can be life-saving. And that's the whole point. That part of a safe workplace is ensuring that we can prevent serious injury or loss of life. And this is where it ties back. So, unfortunately, there's not a lot of direction to provide on this quite yet, but it will be those high risk settings. So I will say, certainly if there's been an incident in recent history in your workplace, I would take that step to get that in order and perhaps look into having this in place, because I think that that's going to be one of those tangible factors both the Ministry of Labor or anybody reviewing or checking will look to. Certainly if you've had an incident, then there might be potential risk of one going forward. So it will all be based on that contextual analysis of your workplace.
Excellent.
I think there's also opportunity to provide training for your employees and how to identify those individuals that might be at risk, because I can see it kind of without the regulations right now. I know that will come, but I can see, some hiccups with supervisors maybe making a wrong assumption And so that training piece will be key.
Yeah, actually, it's an excellent point that you're making. And I'm looking at the time and I'm wondering, usually what we do on Espresso is that we give our guests actually a chance for like a 30-second, minute-long wrap up. But I'm wondering if for your closing comments, if I could direct them in a certain direction, because there have been a lot of comments indicating that the Working for Workers Act has not gone far enough in light of the crisis that we have right now, that employers are experiencing in attracting employees to their workforce. So this is where we're at right now. This is how far it has gone. But how can we encourage and employers maybe to, what else do they or could they put in place that's maybe not reflected in the act yet, but that would speak to actually bringing and encouraging individuals to come on board with those organizations. So I don't know who wants to go first, and I apologize ahead of time for hijacking your closing comments slightly a little bit, but I don't know, Vita, Erin, anyone who wants to go first? Vita, do you want to go first, maybe?
I think you're right in your assessment. I think that what we saw, and and not with any political affiliation attached to it, was a lot of taglines before an election. Right to disconnect, working for workers, Digital Platform Worker Protection Act. But what we've seen in substance is that a lot of these are not, the legislation doesn't really indicate what those taglines looked like. So it's really a very discretionary in terms of the employer in how they implement these. Of course, with the right to disconnect, that's part of it, is to say that, what are we going to do? What are our values as an organization that we want to incorporate into this? So there is a lot of flexibility, and I think that that's what I would encourage. At the end of the day, talent attraction, talent retention is going to be top of everyone's mind for the next, for the foreseeable future, given the current labor market we're in. And I would say go back to your values as an organization. Then use that as your starting point for how you're going to prepare your policies. What are your expectations in line with those values? Try to incorporate that, because you're going to attract the type of talent that your values dictate as a corporation, as an organization, as a workplace.
Thank you very much.
I agree with Vita on that. All other things aside, even the legislation, when you're thinking about it, link it back to what you want your culture to be. Does however you draft things, does it fall in an alignment with your strategic goals, your values, those sorts of things? Nothing more to add other than that.
No, and actually I appreciate both of yours, and I think it's a very valid point to actually wrap up this webinar on, is that yes, this is in place, but likely we can also do better, be more transparent, and possibly reach even further in an effort to actually retain the talent we want, attract the talent that we want, and build the success that we want within our own organization. So to both of you, Vita and Erin, it's been wonderful to spend this past hour with you, and to thank you so very much for your time in addressing all the questions. And to our participants, thank you so very much for joining us. This webinar today has been recorded and will be available on our website at gncc.ca, and it will also be emailed to you directly. And on that note, thank you everyone for joining us, and I look forward to seeing you sometime soon again, maybe on part of our Espresso series, or even better in person. Have a great weekend.
Yeah, thank you.
Thank you, everyone.